Welcome to our Data Protection in Practice webinar for March. Thank you, everyone. Thank you, Irene, for the confirmation. Thank you for joining today's session. It's been a wonderful year. We have started well. We have done a lot since the beginning of this year, and it has really shown the way we have grown as a community. So we started with privacy by design. I don't know how many of us could remember our last webinar when we had privacy by design. If you can still remember, just drop a yes or an emoji on the chat so that we're sure everyone is learning and also practicing what we are learning. So just to build on privacy by design, where we have begun from, we are looking at moving a step further towards privacy by default, where governance becomes real. This is just where we have lots of governance structure, privacy by default. And in today's session, we would be really deep diving into that area. We have a wonderful guest on the call who would help us go through every important and foundational aspect of privacy by design. So, just to quickly remind us of our last masterclass, where we explore how to embed privacy into systems and architectures. And now, today, we'll be deep diving into operational control, regulational defense, decision making, discipline.
Hi.
These are areas. All right. So, um, quickly, we'll be deep diving into privacy by default, a wonderful conversation around governance posture, and we'll be looking at answering a lot of questions around this space, this topic, privacy by default. And to do justice to this topic, I'll be inviting to the podium Winnie Njigi, a wonderful person. She is well exposed. She has grounded knowledge around this aspect. Our speaker today, a fellow of information privacy, certified CIPPE, CIPM, and she's also a privacy law and governance practitioner with cross section experience spanning through banking, fintech, insurance, healthcare, education, and also faith based institutes. So she'll be doing a whole lot around this. She's grounded. So pick your notes, jot your questions, and let's take it up from here. So, Winnie, are you ready? You have the
Yes,
floor.
yes, I'm ready. Yeah, I'm ready. Thank you. Thank you, Izu. So I think we'll just start. Given you already have a background on privacy by design, I'll just be taking you through privacy by default. From where I sit, what I usually say is you cannot separate privacy by design from privacy by default. You require I'd say the two sides of the same coin. And how I'd want us to go about this is to also deeply interrogate this privacy by design principles as Dr. Anne Kavukian defined. So, in terms of privacy by default, I look at it this way: you have a house, you're a contractor, you have a beautiful house that you've built but you've decided to minimize your costs. So because you want to minimize your cost, you've decided, okay, let me not put in doors, let me not put in locks, so that when the tenant comes in, then it is up to the tenant to decide the kind of doors that they want, the kind of locks that they want. Ideally, this is not something that a regulator in the building field would allow you to do, because it means you're shifting your responsibility from yourself back to the customer. And that is pretty much what privacy by default requires you to do. You need to ensure that from the moment you're bringing in a system or you're trying to change your processes, you're trying to bring in new processing activities, you need to ensure that there's always privacy at the back of your mind. And this means you need to respect the right to privacy of an individual. Always remember that at the end of that data set that you're collecting as an organization, there is a human being. And as long as you have that into perspective, then it makes your work a little bit easier. So, in terms of why privacy by default is important, it's because I'm sure most of us have seen how regulators within, and even just globally, within the continent and even just globally, we've seen how they're very fast, they're also very savvy, and they're willing to actually enforce the data protection regulations. And how would they do this? They will come and audit you, because the data protection laws that we currently have given the data protection authorities the mandate to come and audit you as an organization to find out if you're actually compliant with the different data protection regulations that you're required to comply with. For instance, if you are a multinational, it means you're operating in different jurisdictions. This means that if you're operating, for instance, in the UK or within the EU region, it means you are at risk of facing a penalty of up to 4% of your global turnover. If you're also based in Nigeria, this goes up to 5%. If you're in Kenya, it's 1%. So you begin to see that if you're a global organization, you will not just be penalized in the country where, say, your HQ is based. You're likely to be penalized even in other jurisdictions where you're based. So it makes it important that you ensure you always have your privacy settings within your systems, within your processes. They need to be at default. The individual as a customer, they do not need to make any additional measures or any additional steps to ensure that their privacy is protected. For example, if as a user I visit your website today, you have tracking cookies. So you're tracking me across the different platforms that I get into. What you're trying to do is you're trying to push maybe a product, you're trying to push a service. And maybe the only reason why I went into your website was maybe I was trying to say apply for a job opportunity, but you're now tracking me and you're pushing your products to me. As a customer, of course, I'll decide either to download a browser that will allow me not to get tracked. For example, I could download something like Brave, which does not allow tracking. It does not allow you to push your ads to me. So at the end of the day, we are both losing. Maybe I could get value from your service, but I feel like you're being creepy when you're following me across the different platforms that I'm trying to get into. So to start with, I want us to go through the first principle of privacy by design, which is be proactive, not reactive. And the lens for privacy default in this is you need to always try and anticipate some of the challenges that you're going to face as an organization. For example, if you want to register um, a digital credit provider facility in your country, for instance, if you're in Kenya, you want to try have an equivalent of, say, Tala or the likes. The regulatory requirement is, and this is both for CBK as well as the Data Protection Commissioner's Office, you'll be required to have a privacy notice, or you'll also be required to have a data protection policy. But what usually happens is you find that your privacy policy says one thing, but on ground, different things are happening. For example, you find maybe your privacy notice says you retain data for, say, 7 years, but in practice, you retain data indefinitely. So if your organization is 40 years or it's 50 years in existence, it means that you've never deleted any data, you've never archived any data, and also the more the data you have, the higher your chances of risk. So if a data breach were to happen and you have shadow data, what do you think would happen to you as an organization? So one thing you need to do is always ensure you've put in place access controls. Who within the organization can access your data? Why do they need to have access to that data? Is it because they have a role that they need to play? They need to use that data to perform their role, or they just have access because it's just there. There are no permissions limiting who has access. What do they have access to do? What can they do with the data? What can they do with the data? The other issue is also in terms of consent management. I'm sure most of us have gone to an event in your country. If you've gone to an event, at least I've seen this mostly happening in Kenya and in Tanzania. So, what most marketing organizations are doing or event companies are doing is you have an event happening, say next week. You've decided that you need to have a tick box way of complying with the data protection regulations. So, what do? You go to ChatGPT, you decide to ask it to create for you a privacy policy. Of course, it will give you a generic one. So, you'll get the privacy policy. You will not review to see if it even discloses who the data controller of that data is. You will also realize it might not even disclose how long you're going to retain that data for. The other thing is the assumption that because you have a privacy notice, now you're allowed to process the individual's data. So anyone who walks into that event, by default, in your mind, you feel like that this person has already consented to us processing their data for the purposes of event management. But what you're failing to realize is that consent has to be written. It has to be specific for the specific purpose. So if it is not written and someone writes to you asking you to delete their data, how are you going to tie it back to that individual if you don't have, first, you don't have the consent in place, and two, you don't have consent management in place? The other challenge I've also seen is you might have the consent forms in place, but where are they stored? And can you easily retrieve those consent forms and actually actualize the request to delete or to withdraw consent? So if on one end your system is collecting a customer's data, but on the other end your marketing tools do not have a capability to actually implement the opt out mechanisms that the client has decided to opt out from, then you automatically become non compliant. And we've seen very many cases across the continent where organizations are actually getting penalized because of a simple mistake where they didn't obtain consent or they were not able to actually with enable that individual to withdraw their consent. So anytime you're designing your consent form, ensure you have a clear privacy notice that explains to the individual what data you're collecting, why are you collecting this data, and also, if you have a form, always ensure that that form only collects the minimum amount of data that is necessary for your specific purpose. For example, if it is an event, again, you only need maybe to have an individual's name, say, and their email address, or maybe only their phone number for purposes of communicating more about the event or for security reasons. But if you go over and above and start collecting additional informations, automatically you become non-compliant, and that approach that you're using is actually not a privacy by default sort of approach. The other thing is in terms of culture. If as an organization you've done the best you can, you've done your DPIs, you've put in place access control, you've put in place consent management, but you're lacking in terms of the awareness of your respective teams. Because in as much as you have all these technical measures in place, most of the time your highest risk is from your staff or from your employees. So if they're not trained on data protection, they're not trained on what the responsibility of the organization is, then you will begin to fail. So you become an organization that is reactive. So yes, a complaint has come. What can we fix immediately so that the regulator is off our back? The other thing is privacy embedded into design. You need to ensure that from the onset, if you've decided today you want to come up with a, say, an app, you've decided you want to come with an app today, you start with your engineering team, you've sat down with your legal team, you've sat down with your compliance team, and they have told you you need to have these minimum measures in place. But because the business has decided, or the business wants to get the maximum benefit from this solution, you decide to turn off or to toggle off some privacy measures. For example, you decide, we want to know what our customers like. We want to know the websites that they visit. We want to know their behavior so that we can push certain products to them. So in your website, you have cookies and you have a cookie banner, which is nice. But in your cookie banner, all the options are toggled on. So it is up to the individual to decide what they want you to have access to, or how they want you to track them. So if this happens, as an individual, again, as a customer, I'll feel that my rights have been infringed. So if you do not have a way to manage consent, or you don't have a way to manage access controls, or you don't have a way to manage your consent design, then automatically you also become non-compliant. And the other thing with privacy, embedding privacy into the design, it means anytime there's a change in your process, or anytime there's a change in your processing activities, you need to go back and think about the privacy of the individual. How is this new process affecting the individual? One of the things I have found to be really helpful as a tool is having a ROPA, for instance. If you have a ROPA, that is a records of processing activity, you're able to tell how the data flows within the company. So that, for instance, if today you change your service provider, your cloud service provider, for instance, then you can always go back to the ROPA and update that. But if you don't go to the ROPA and update, chances are you could miss having a data processing agreement or a data sharing agreement with your service, with the cloud service provider. Then we have the principle of positive sum functionality. So for this principle, how I'd put it is, as a business, you don't have to make unnecessary trade-offs. Yes, we do get that you want to get the maximum level of benefit from your product or from your marketing campaigns. But the data that we have right now tells us that consumers are looking at organizations that are actually keen on protecting their right to privacy. How then do you demonstrate that you're actually keen on protecting their right to privacy? You need to embed this within your systems. So this starts from the moment you're collecting that data, right? So say you're an organization that does, say you're a hospital, for example. So you're a hospital, and you have insurance companies that are on your panel. So as a hospital, what is the minimum amount of data that you would need from me as a patient for me to get a service from you? For instance, if it's not my dependent that is coming to the hospital to get the service, in your forms, then it means I do not need to necessarily disclose this information. So within those forms, the other thing you need to ensure is always disclose what is mandatory for an individual to disclose and what is optional. And the other approach, how I would look at it is, if it is very necessary for you, for instance, to track an individual across different platforms, or you really need this data, for, say, for marketing purposes or for analytics purposes, can you design it in a way that does not necessarily infringe, or a way that is not very intrusive on an individual. And then this goes back to the point I had made on doing a data protection impact assessment. At the core of it, a data protection impact assessment will allow you to see your data flow, first of all. It will also allow you to review what what measures have you put in place to protect the customer's data. For example, it will help you look at whether you have put in place proper access controls within the organization. It will also help you look at whether there's a contract between you and a third service provider. If that is necessary, it will also help you look at how you're implementing the different lawful bases as well as the data protection principles. The other thing it will help you do is assess your risks. If, for example, you've realized your service provider doesn't have a data processing agreement, then at that point, as the privacy person in your organization, then you have something to go back to the business and ask them, you guys, you need to check this particular service provider, they do not have a data processing agreement. Or you can go back to the IT team, even before this particular product is rolled out or this particular system is rolled out. You can go back to the engineering team or to the IT team and tell them, you need to fix this, because if you don't fix it, then it means the regulator will be on our case. For example, you can go back to the design team and tell them, we don't need to have all the options on the cookie banner automatically toggled off, because we become non-compliant and we face the risk of actually getting penalized by the regulator. The other thing is end-to-end security. So for security, you need to ensure that at every touch point of your data, there's a security measure in place. For instance, if you have a web-based platform, for instance, that is collecting data, it means there is a database somewhere. So from the web, first the web needs to be secure by default. So what measures have you put in place to ensure that this is actually happening? Then you go to your database layer. So in your database, how are you protecting that data when it is at rest? Have you encrypted that data? Do you have the necessary firewalls? Have you also looked at who has access to that particular database and why do they need to have access? So the other thing you also need to do is always map out your organization and look at, for this particular role, does this individual need to have access to everything in the database, or do they only need to have access to this particular segment? For instance, if you have an HR system, this HR system also has, say, ATS. So you've collected people's CVs, you've shortlisted who is going to get the position, you've done the interview, they've actually been onboarded. The thing you need to also look at is, for these people that were not successful in this particular round of recruitment, what do we do with that data? Is it data that we actually need to fulfill any particular purpose? For example, is there, say, a legal requirement to retain this data? Or do we need to go back to the individual who gave us this data to ask them if we can keep this data, maybe for consideration in future? If not, you need to find a way to deal with this data. You can either delete it or you can archive it. From where I sit, I'd say the best approach is delete it, because you do not need it. The other thing to also consider is data retention for all your data sets. I had mentioned an organization, say, that has been in existence for 50 years. This is an organization that has so much data, some of which they would not even know where it sits, on which platforms it sits, whether that data is actually secured. For instance, if it's a legacy system, chances are if you've moved to a new system and this data still sits in this legacy system, it does not undergo routine patching. So if it doesn't undergo routine patching, it means it is very vulnerable. If anyone wanted to exploit it, they can exploit it. For those of us who are in Kenya, I'm sure, I think it was earlier this year or late last year, where It was Mtipa that suffered a breach, and they lost so much sensitive data. And one of the issues that came up was, for them, they had data that went so many years back, and they really didn't need a reason to have that data. So if they had deleted that data, or they had found a way to secure that data, what happened would not have happened. Then the other thing is visibility and transparency. How I like to approach it is, as an individual, if I look at your privacy policy, for example, is it clear for me how you're going to use my data? How are you going to process my data? Are you going to share my data with a third party? If so, why are you sharing my data with that third party? If I cannot be able to establish a rational link between the reason why I'm giving you my data and the reason why you're sharing this data, or the reason why you're using this data, then automatically I could opt out. At least that is for me. With and being this is me being a person who is in this space, who reviews the privacy policies, who reviews the privacy notices. But majority of us, I'm sure we have different social media platforms on our phones. But how many of us actually take the time to go and review that privacy policy and see what the organization is using your data for? The other thing is, most of our privacy policies are either too big, too bulky. They use language that an ordinary person would not be able to quickly decipher what it says. And if it is not clear for that individual, most of us will just accept and move on. But if the regulator came and looked at your privacy policy, because of course that would be the first place that they would start. You have a privacy policy on your website. Someone has made a complaint that they reached out to you to effect any of the data protection rights. But because you have a DPO email there that is not working, you never received this communication or this complaint from the individual. So you didn't respond to that particular complaint, and it went over and above the regulatory timelines, depending on the country, also depending on the right. So, for example, if it's in Kenya, say I made a request for data deletion. The privacy policy on your website says this is the contact information of our DPO. I write to the DPO, I don't get a response, or it doesn't even go through. So I make a complaint to the regulator. So the first time you're realizing there's an issue with your privacy policy or with your email is after the regulator has found a way to reach you as an organization. So these are some of the questions I'd want us to ask ourselves as we look at how our organizations are actually implementing this principle of privacy by default. Do your users or customers know what data you process about them and why? Can your users effectively exercise their data protection rights? Because if, for instance, it was easy for me to consent to you as an organization processing my data, either it was physical or it was in your app. But now, when I want to withdraw my consent, I have to go through hoops to be able to do that. As an individual, of course, I'll be aggrieved. The first thing I'll do is make a complaint to the regulator, because that process should not be too lengthy. It should be as easy as it was for me to get to give you my consent. The other thing is, have you tested your opt-out mechanisms? What I've found to be lacking for most organizations is you have a nice consent form. You have also disclosed how you're going to use an individual's data. You have disclosed how long you're going to retain that data. You have given me as an individual assurances that even within your organization, you've properly defined who has access to what and why. That is okay. But there's a challenge, because yes, you have all this. I have withdrawn my consent. You have acknowledged that I have withdrawn my consent. But your marketing tool and your core systems, they're not communicating with each other. So if I withdraw my consent and it does not reflect on your core system, it means if you move vendors, that data is still in your core system. So your next vendor will just come, pull that data and blast marketing communications to everyone on that list, which makes you automatically non-compliant. The other thing to think about is how much effort does it take to see or to get your privacy notice. I'm sure most of us have opened websites where you can't even tell if there's a privacy policy. And even before you get to that privacy policy, uh, the interface is so convoluted that the only option you have is accept all and move on. If that happens, and that is called a dark pattern, that does not have the user in mind, it does not have the data subject in mind. Because what you're trying to do is force that individual to actually um, continue with your platform, continue with your service without questioning it. The other thing is, do you maintain a do not contact list? There are people who, of course, automatically they don't want to be contacted, or this is someone who has written to you to opt out. If you do not have a do not contact list and your core system and your marketing system are not communicating with each other, it means you will eventually end up sending this individual um, the marketing communication. And the other thing is, do you comply with the retention limits in your privacy notice? It's one thing to say we'll retain your data for up to 7 years, after which we'll delete or we'll archive. But if you're to be put to test today by the regulator, if they were to come to you and ask for a log that shows the data that you have deleted and when you deleted that data, can you show them that, yeah, we do indeed have a log? The other thing is to also consider, do you have a data retention schedule? Because obviously not every category of data will have the same retention periods. So it could be employment data, which reflects in a different law, maybe the employment law. It could be criminal history, which is reflected in a different law. So if you decide to have just one blanket retention period, not only will you be non-compliant with the Data Protection Act, you'll also be non-compliant with the other regulations that you're supposed to comply with. So what I always say is data protection does not stand on its own. It is also dependent on the other laws that surround your ecosystem. So for data retention, always make reference to the other laws that your organization is required to comply with. Then the other thing is respect for user privacy. As an individual, if you're processing my data as an organization, one of the key things I'd want to know is that that data will not be used against me, or you will not collect extra or unnecessary information from me. For example, if I seek employment at your organization today and I decide to just disclose my data and I don't disclose data about a spouse or children, but for some reason you feel like you would need this data, maybe because you offer insurance or you offer pension benefits for an individual, and you decide to go and collect that information, or you decide to reach out to someone else for you to get this information, and now this information is in your system. If I went and made a complaint against the organization will definitely be penalized by the regulator. So the overarching principle here is data minimization. Only collect what is necessary for your specific purpose. And this applies across whether it's you have an app, whether it's a physical form that individuals need to fill. You need to ensure that you're only collecting what is necessary at a bare minimum. And always respect a user's choice to opt out from your processing activities. So, in terms of my takeaways for this particular webinar, is always have a way that the regulator can always have evidence of what you've done. If you tell a regulator you've done a data protection impact assessment, they'll not just take your word for it. You need to show them that This is the data protection impact assessment for this particular system that we're implementing, or for this particular system that we want to implement. The other thing to always remember is, in as much as you could decide not to submit this data protection impact assessment to the regulator, you still need to maintain a copy of it. The other thing to also always ensure that you have in place is logs, and these are system logs. So if you have systems in your organization that you're using, always look at who has access to those systems, and can you actually go back to the log and look at, say Winnie had access to this particular system or this particular portal on this and this day, and this is what they did. Did they download a document? Did they upload a document? Did they edit a document? If you have that, and maybe there's a complaint that has been made against you, then you have a way to defend yourself. The other thing to also consider having is the data retention schedule that I had mentioned. It's okay, you can have the data retention policy, but if it is just a policy that sits on your intranet and it's never, first, ever accessed by anyone, and two, people are not able to tell how long you're going to be able to keep their data, and even internally, your different business teams are not sure, or they don't know how long they're supposed to keep data and how they're supposed to delete that data, then you're automatically in trouble with the regulator. The other thing to also check as an organization is your consent management. How are you documenting consent? Do you have a repository within the organization where, say, all your consent forms are going into? And are you able to effectively enable an individual's right to withdraw their consent? So, can you tie this specific type of data to this specific individual? The best way to do it is always ensure it has a date, it has a time, and it has the individual's signature. So you're able to tie it back to the individual. The other thing to also check is, are your tools communicating with each other? If your marketing tool um, does not have a way to communicate back to your core systems, it means there's a problem there. Because if someone withdraws their consent and you're not able to have that effected in the core system, it becomes a problem if that data is used, say, to market or for any other purpose. The other thing to always remember also is your purpose of collection. If your purpose of collection is you're only collecting this data for, say, purposes of employment, or say someone has come into your facility, maybe you're a cafe, maybe you're a supermarket, someone has come into your supermarket or they've come into your cafe, they have paid for their goods and they have left and gone home. But because they've paid using mobile money, you decide to collect this data automatically and put it in your marketing tool. That means whenever you're doing promotions, then that individual will also always be getting that marketing communication, but they never opted in to receiving that marketing communication. So it makes you automatically non-compliant. And the worst part of this is, for most organizations, what you'll fail to do is give that person an opt-out mechanism, and also ensuring that that opt-out mechanism actually works. Because if you have it there and it doesn't work, it's still the same problem. You still have consent issues that you need to fix. Then the other thing is that a good privacy program anticipates risks. If you're as a privacy professional, the one thing that most businesses will not like or will push back from you is when you try and question the data, or you try and question the security safeguards in a system, because most organizations will look at you as a blocker to innovation. But you always need to remember that you're there to support the business. So always have these conversations with the business as early as possible. And also, as a challenge to businesses, your privacy team is actually your biggest ally. They could tell you where your issues are and you could fix these issues, not only will you be compliant with the required data protection regulations, but your customers will also have trust and faith in you as an organization. And it could be your selling point. It could be what separates you from what your competitor does. For example, most people who have iPhones or Apple products, one of their key selling point is privacy. And as long as that is your key selling point, especially now when individuals are increasingly becoming aware of their data protection rights or their privacy rights, then that's a good selling point. So you don't need to make any unnecessary trade offs between innovation or respecting a user's privacy. That's it from me. Open to questions.
And I think you'd first need to turn off the.
Give me a minute. I am really struggling with this platform. It's new.
Right.
It's-
Oh, you can keep your camera on. Thank you very much, Winnie. What you highlighted was extremely insightful and, more importantly, very practical. You've highlighted a critical point that privacy governance is ultimately expressed through system defaults, not just documentation. Now, I don't know if people will put anything in the chat. I've got a couple of questions for you there. The first one would be like, how can organizations balance usability and privacy by default without introducing excessive friction for users?
How I'd approach it is look at it from the individual's perspective. Remember, I said at the end of the day, it's an individual behind that data. You might want to push all the products in the world, you might want to push all the systems in the world. But if your customer is not happy, if your customer is not satisfied, then chances are they will go to your competitor. So the best place to start is always have them at the back of your mind. It's their privacy. Think of it this way. You as an individual, would you do the same thing that you want to do? Would you want an organization to track you all around all the platforms you're getting into? Obviously not. But there's a way you can configure your systems to ensure you're still getting the analytics, you're still getting the aggregates, but it does not identify the individual. You're still getting the data you need, but without it being, now this is Winnie, she was in our platform and she has left our platform and she's gone to this other website, or she's looking at something else. If, for instance, those two things are not related, maybe I got into your platform to check a job, then I move to the next platform and I'm looking at shoes or I'm looking at suitcases. But you're here still pushing your other services as an organization. It doesn't really, like, it doesn't make sense.
Yeah. And just out of curiosity, what is the one default setting you believe organizations consistently underestimate from a risk perspective?
And this one is my biggest pet peeve, is when all cookies are automatically toggled on, or for me to access your system, that there's a paywall, or there's this case in the EU of Meta, where Meta, the option they were giving individuals is you pay or you consent.
Well,
Yeah.
what do you think would be the first practical step organizations can take to improve privacy by default?
The first step for me would be obviously doing a data protection impact assessment. A data protection impact assessment will help you have a holistic view of your processing activity or of the system you're trying to implement. It will help you look at your how you're implementing the privacy principles. It will help you look at how you're implementing the lawful basis. It will help you look at your risks, your systems, your stakeholders. It will bring everyone to the table, because most of the time you find that as the data protection officer or the privacy officer in most organizations, most people will come to you when there's an alarm or there's an issue that has now materialized. But if you do a DPA and you're involved from system development through to deployment, then it's as easy as just showing the regulator that we've actually done a DPA. These are the risks, and these are the mitigation measures that we have in place. You can always go back to it and revise it and review it. The other thing I'd also say is records of processing activity. It tells you where your data, how your data is moving through the organization, including telling you how your retention periods are. So you're able to segment the different types of data that you are processing as an organization and the different retention periods that you need to comply with. So when you have these two tools, you're good to go.
Oh, that's actually quite insightful. Thank you so much, Winnie. So as we wrap up, I would like to just highlight one key takeaway from this session. Privacy by default is not a technical afterthought. It's a governance decision that's embedded into systems. And given that organizations will probably be assessed according to this in the future, it's something that I think, all organizations should really look into investing in. Winnie, thank you again for sharing your expertise and practical insights with us today. To the audience, thank you for your time and engagement. I'm just going to bring somebody on over. Melissa, I'll just ask Melissa to come on to share some announcements from the network.
Hello, everyone. I'm here with some announcement. Firstly, I'd like to let you know that you're invited to join fellow DPOs and compliance leaders for the monthly DPO Africa meetup. It's a forum dedicated to addressing Africa's most urgent privacy and compliance challenges through peer driven collaboration and solution development. Prince will add the link in the chat. And this is on Mondays. Next, we've got the DPO Den. This is coaching for success. It's a focused $99 coaching experience created for data protection and privacy leaders who want more clarity, confidence, and career momentum. It started this January. In it, you get one-on-one coaching plus small group sessions in a safe yet powerful space where you can grow, experiment, and be challenged without judgment. If you're ready to reposition yourself, expand your influence, or scale your privacy office this year, this cohort is for you. If you've got any questions, kindly reach us on info@dpoafrica.net. For bookings, Prince will add the link in the chat. Then we also have the training store with various courses for starting and experienced DPOs alike. We now have AI enabled support for any issues. And as always, if you still need that human touch, you can email info@dpoafrica.net. Book if you're looking for a book on operationalizing theory that has been endorsed by many industry regulators and privacy leaders, look no further. There's the Data Protection Foundations, which is a practical guide to privacy, governance, and trust by our founder, Amaka Ibeji. This book is not just about theory, it's packed with practical, actionable guidance. Many of us have contributed to reviewing this process, and we're so excited to see it being published. So you can get it in the link below. On that note, we also have the Policy and Practice Working Group that is currently going through the book. If you'd like to see what the book is all about, you can join one of our sessions as we review it chapter by chapter. Finally, we're forming a small study group committed to AIGP for members of DPO Africa Network who are preparing to take the exam in the next 2 to 3 months. I will be leading this as I also want to be certified in AIGP. So we welcome you to fill out the form that's going to be added in the chat, and we can meet up. This group is going to run from mid-April to mid-June. So this means the target would be to write the exam in June of 2026. There'll be weekly virtual meetings and shared accountability. To apply, please fill out the form in the link below. And selection will be based on readiness, exam commitment, and the ability to participate consistently. So just to let you know, for the study groups, we actually had one for CIPPE last year from June to August, and a majority of the people in the group are now certified. So I'd encourage you to join us. Over to you, Prince. Thank you, everyone, and have a good evening.
With that, I would like to say thank you to everyone for your time and for joining us in our sessions. We'll ask you to tune in next time when we have our next industry expert ready to share their experience with us. Till then, thank you and goodbye.